From KBIA and the Reynolds Journalism Institute, on air and online, this is Intersection.
Hello and welcome to Intersection, where people and ideas meet online and on KBIA. I'm Ryan Ferguson. Last week, a Missouri Court of Appeals vacated the conviction of Ryan Ferguson. Listeners might recall Ferguson as one of the two men accused in the 2001 murder of Columbia Daily Tribune Sports editor Kent Heitholt. In its legal opinion, the appeals court said the prosecution violated Ferguson's due process rights by withholding favorable information from the defense team. In this case, it was an interview with the wife of a key witness that could have undermined her husband's testimony. This type of evidence suppression or withholding, which is known as a Brady violation, may be more common than you think. A 1999 Chicago Tribune report on prosecutorial misconduct found that 381 homicide convictions were later vacated because prosecutors hid evidence or allowed witnesses to lie. Today on Intersection, we're taking a closer look at Ryan Ferguson's case and to learn more about Brady violations. Joining me in studio, Bill Ferguson is the father of Ryan Ferguson. For years, he's advocated on his son's behalf. Bill, welcome to the show.
Thank you.
Rodney Uphoff is a professor in the MU School of Law. Before coming to MU, he taught at the University of Oklahoma College of Law and the University of Wisconsin Law School. Before becoming a law professor, Uphoff was a public defender. Rodney, thanks for joining us.
Welcome to be here.
John Roothouse is a partner in the law firm of Jones, Schneider, and Stevens, LLC. He's also worked as a Boone County Assistant Prosecuting Attorney and Assistant Attorney General for the state of Missouri. John, thanks for being here.
Thanks for having me, Ryan.
And joining us by phone, Charles Atwell is an attorney with the law firm of Foland, Wickens, Eisfelder, Roper, and Hofer, PC. Before that, he was a circuit judge in Jackson County. Full disclosure, Atwell also worked with the law firm of Weissrick, Atwell, Mirakin, Lee, and Hobbs, which represented Ryan Ferguson, although Atwell was not directly involved with the case. Charles, thanks for joining us.
My pleasure, Ryan.
All right. We'd also love to hear from you in our audience as well. What questions do you have about the Ryan Ferguson case? Give us a call at 573-882-8925 or email intersection@kbia.org. You could also tweet us at intersectkbia. So to start, Bill, maybe we start with you. Just in general about this the vacated sentence last week. You had some time for this all to sink in. What's your reaction up front to what happened here, and where are you going from here, I suppose?
Well, my immediate reaction is what took so long. Well, it's taken a decade for something that the case had no merit as far as we're concerned initially, and it's taken 9.5 years and numerous appeals just to get to this stage, and to have the sentence vacated is exhilarating to say the least. So we're very happy.
Yeah. And so what is your attorney Kathleen Zeller telling you? What's coming ahead here though in the next few weeks and months?
Well, immediately we don't know when Ryan will actually be released. The sentence is vacated. As a matter of fact, if you pull up his name at the prison, it's non grata. His name is not there. So I'm not sure what that status means. But he's definitely there, and we're hoping that he'll get out Wednesday or Thursday. Earlier would be nice. And then once that happens, it will be up to Kathleen, what our next, Kathleen Zeller, our attorney, as to what we do next.
Right. And so for him to be out then, that would have to be because you guys have put in a request for bond at this point.
We did, and that make that decision tomorrow. It was 15, then we had a bond hearing to be held on the 7th, on the Tuesday, 7 days later. And then they have to make a decision. So hopefully he'll either be released completely, unconditionally, or we'll post a bond.
Sure. We've again got a variety of legal experts here as well. For those of you that have been following this case, what are your initial reactions to what the court put out, this appeals court last week, and what it said, and what it means going forward too?
Well, I think I should say from the outset that I haven't really followed this case very closely, and that this occurred at a time before I worked at the Boone County Prosecutor's Office, so I don't have any inside information for you, unfortunately. Sure. But I think in reading the opinion, I think what concerns me is not necessarily the result that was reached. And again, I don't know enough about the case to comment as to whether or not the conviction should have been vacated or not, but I think having worked in a prosecutor's office, having worked with the Attorney General, and seeing some of the language that was included in that opinion, I'm very concerned about what that can mean going forward for the administration of some of these law offices.
Mm-hmm. And I guess, Rodney, too, could you help us a little bit on the process going forward as well? We talked a little bit about with it, Bill, here, but...
Well, specifically, I guess what John's referring to is the question of Brady and a Brady violation here. And so the opinion is critical of the then district attorney, Mr. Crane, who is now a circuit court judge. But the opinion states very clearly that it felt that this was important exculpatory material that should have been turned over as both a statutory and constitutional matter, and its failure to do so, in the court's view, undermined the court's confidence in the verdict. Because if you look at the opinion, there were really two key witnesses who testified against Ryan Ferguson. The first was Chuck Erickson, the co-defendant. So his testimony was essentially a confession and said, I was involved and Ryan Ferguson was with me. So that was the linchpin of the state's case. But the corroborating witness was the janitor, who essentially said when he came out of the building, he saw two people in the alley. When he first, he said, I saw these two people, but I didn't know who they were. Then his explanation for why it was that he suddenly was able to tell that it was Ryan Ferguson, Chuck Erickson, was he contended that he got a newspaper article while he was in prison. It was folded in a particular way, so he saw the pictures, but there were no names. And as soon as he saw the pictures, he testified at trial, he recognized the two people as the two people were in the alley. And it was only when he unfolded the newspaper did he then claim that he saw that it was Chuck Erickson and Ryan Ferguson, the names connected with the photo. Well, as the opinion lays out, the prosecutor sent one of his investigators out to speak with the wife of Jerry Trump, was this witness. He sent his investigator out to speak to Barbara Trump. And Barbara Trump was asked about sending the newspaper article, and she said, I have no recollection of sending a newspaper article to Jerry Trump. So the investigator should have prepared a report, provided this information to the prosecutor, who in turn, under a case called Brady versus Maryland, this is classic exculpatory material, this material should have been turned over to the defense. Had it been turned over to the defense, they would have cross-examined Mr. Trump and may well have been able to discredit his testimony. So that's why the court ultimately concluded we're uncomfortable with the final result, because if you strip away Trump's evidence, that leaves only Chuck Erickson's testimony. The court did not say necessarily that it felt, in fact, it did not address the actual innocence claim, but it said, given the Brady violation, we're satisfied that we are not confident in the verdict, and therefore it overturned the conviction. So I think the larger problem identified here is one of the extent to which prosecutors are, in fact, complying with their obligation under Brady to turn over all exculpatory material. I want to make it clear, and maybe this will reassure John, I think the vast majority of prosecutors do turn over exculpatory material, but unfortunately this is becoming all too common where material, not just recently and not just here in Missouri, but across the country, this is a national problem where we have a certain number of prosecutors who are not living up to their obligations, their professional obligations, and this is causing a problem for our judicial system.
Well, there's a few aspects of that I would take issue to. I think that's a fair characterization of what the Western District stated in its opinion. However, when I knew I was going to be on this radio program, I read it a little bit more closely the second time, and I think one of the things that really concerns me about this opinion is that there's a glaring factual dispute on this particular issue. Mr. Uphoff, just characterized it as Kevin Crane sending an investigator out to talk to Mrs. Trump prior to trial. Well, actually, the testimony of some of the witnesses is that this was a phone call initiated by Mrs. Trump after she was called by Mr. Ferguson here, and this was several months after the trial. And that's a pretty big factual problem to have on something, a legal issue of this significance. I don't know why, and I don't know if the blame lays at the feet of the state for not clarifying the record better, or for the court for maybe not remanding this for more factual proceedings. But It's expressed in a footnote. The decision does acknowledge this factual dispute as to whether or not this contact between an investigator and Mrs. Trump occurred before or after trial. The other issue the other thing that he mentioned that I think is incorrect is that the record is pretty clear that Mr. Crane had no knowledge of this contact between his investigator.
Oh, it's nothing to be proved.
Right.
Yeah.
Well, I didn't say that he had any knowledge. I said the investigator failed to turn over the information to him, so
Right.
he in turn wasn't able to turn over to.
Yeah, but your statement was that Crane sent him out to talk to Mrs. Trump, and that's not true.
Okay, he just went on his own.
Well, from what I understand, Mrs. Trump contacted the prosecutor's office.
Okay, well, I mean, that's not the way the opinion reads, and you're right. I don't know what the facts are. I'm just relating.
The opinion
what the
did go to
opinion
great
says.
lengths to say, and many times, that Kevin Crane may not have known about this investigator and that, I guess, not really important necessarily in proving that this was a real Brady violation.
Right, absolutely, because Kyles versus Whitley is a United States Supreme Court case that specifically said the police are charged, the district attorney essentially is charged with the knowledge of the police. And the reason that it came out that particular way is because there were cases before, and in fact, famous case out of Chicago, where the police actually had two sets of files. They had a set of files that included all material, and then they had a set of files that didn't exclude any exculpatory material. That was the set of materials that was turned over to the prosecution, and that was the set of materials that was turned over to the defense. So what the court said in Kyles versus Whitley is we can't have prosecutors and police pointing at each other and blaming each other. Bottom line is the state has the obligation, and it's up to the prosecutors to set up appropriate procedures and communication with their police so that the prosecutor is the one ultimately who has possession of all the material, and it's the prosecutor, not the police, who makes the determination of what ought to be turned over. So it's not necessarily, I'm not saying that Kevin Crane purposefully withheld this information, but this information was withheld, and neither Kyles nor Whitley requires a showing of bad faith on the part of the defense or part of the prosecution, essentially.
If I could inject here for a moment, if you would go back and examine the testimony of Bill Haas, his investigator, he clearly states that Crane got out of prison in December. I mean, Crane didn't.
Trump.
Probably a Freudian slip. That Trump got out of prison December of 2004, and at about that time, a year before the trial was in 2005, that he contacted Barbara Trump and numerous contacts, at least two or three. So I would suggest that before we get too carried away in these opinions, that we go back and read the transcript from the Habeas hearing, and I think you'll be rather enlightened as to what actually happened from the prosecutor's point of view. And it doesn't match up with what you two gentlemen are saying.
I do take a moment to remind our listeners that this is Intersection, a program of KBIA and the Reynolds Journalism Institute. I'm Ryan Ferguson, and today we're talking about the Ryan Ferguson case. Last week, a court of appeals threw out Ferguson's conviction in the 2001 murder of Columbia Daily Tribune Sports editor Kent Heitholt. Today, we're talking about the legal basis for why that conviction was vacated and some of the larger issues surrounding the conduct of prosecutors. Joining me in studio for the conversation today are Bill Ferguson, the father of Ryan Ferguson, Rodney Uphoff, a professor in the MU School of Law and a former public defender, Attorney John Roothouse, who in the past worked as a Boone County Assistant Prosecuting Attorney and as an Assistant Attorney General for the state of Missouri. And joining us by phone, Charles Atwell is a practicing attorney who was formerly a circuit judge in Jackson County. And for you and our audience, do you agree with the Missouri Court of Appeals decision to vacate Ryan Ferguson's conviction? Give us a call at 573-882-8925 or email intersection@kbia.org. You could also tweet us at IntersectKBIA. We'd like to remind you that you can watch Intersection as streaming video online during our live conversations every Monday afternoon at 2 at kbia.org. You can watch that video and join our online chat by going to kbia.org and scrolling down to the link for Intersection. Again, that's Mondays at 2 online at kbia.org. We have a lot to talk about today, so I'm going to try to jump into something else real quick here, and that is that on Friday there was a special prosecutor appointed in this case. Just to talk about the timeline and what's going to happen from here, Bill, maybe we'll start with you about what you know, what your attorneys are telling you now about this special prosecutor, what it might mean for the process going forward.
All I know about that is that he'll be making the decision or making the recommendation as to whether or not to have a trial or allow Ryan to be released. That's all I'm aware of it.
What about John or Rod or Charles? Anything? What is the state thinking here with making that move? Was that something you saw coming in this situation?
Well, I think it makes perfect sense because there were issues raised, obviously, in the opinion about the conduct of the Boone County Prosecutor's Office. Dan Knight was a member of the office and, in fact, assisted in the case. So I think it was a wise move by Mr. Knight to essentially ask that a special prosecutor come in and make a independent determination as to whether or not to go forward or not.
I agree with that completely. I think given the facts here, it would have been too much of a distraction for the Boone County Prosecutor's Office to try to retry this case again.
Does it mean anything more than that, though, as far as making that switch, as far as the
Well,
process here and what the state's going to have to be thinking about doing?
Well, it puts the special prosecutor in a particularly difficult position because, and I believe it's a she, has a relatively short period of time to make a decision on whether to go forward. And it's a murder case. There was a lot of information that she needs to go through. So we want her to be able to make a truly independent and wise decision as to whether or not to go forward or not. It's significant not only for Mr. Ferguson, but it's significant for the community, for the Heitholt family, and everybody else. So that should be a reasoned decision, and most reasoned decisions take more than 10 or 15 days. So she's in a difficult decision. Nonetheless, I think that was definitely the appropriate way to go.
The other person that you didn't mention there is Charles Erickson. Could the way this process played out mean anything if he tries to follow this path and get out?
Well,
we're going to talk more about that.
Yeah, I think we're going to have an interesting discussion on that because I saw Bill indicating that he thinks that this will ultimately lead to an exoneration for Mr. Erickson, and I would say that he and Ryan are in markedly different positions. It is extremely difficult to undo a guilty plea. And in this case, Mr. Erickson has given a series of statements or confessions regarding the crime. The one he testified at trial, then he gave a subsequent one, then he gave a subsequent one. There may be three, there may even be four, I'm not sure. But I think that it will be extremely hard for his attorney, if he tries to go forward and brings a motion to withdraw the plea, to establish that the plea was an involuntary plea, and that's what he'll have to do in order to, I think, secure his ultimate release. I'd be curious what John has to say about that, but I think he's sledding uphill in trying to get out.
Or maybe this might be a good time to bring Charles in. Charles, it's harder to bring you in over the phone, but what are your thoughts on this, on the Charles Erickson issue here?
Well, I agree with what Rod said. Is because of the fact of the statements he's made in the guilty plea, it's a much different situation, and it's going to be a much more difficult situation, both in a factual sense and a procedural sense. So, I agree with that comment. I might make. I'm really not in a position and don't care to comment on this case in particular, but I think that one thing that we should note about this case is I think it does show a trend over the last 10 or 15 years. In the state of Missouri, where the Supreme Court has tried to use the vehicle of habeas corpus to address, actual innocence claims or what they call gateway claims, and that was a jurisdiction that was somewhat foreclosed for a long time. And I think with a lot of the exonerations that has occurred from DNA evidence and from other organizations, I think that this, in a procedural sense, is a good thing, and I think this is another case that demonstrates that. And I think it's important that we have some result or some last avenue when there are serious questions of the fairness of the trial or the guilt of the defendant. So I think the court should be complimented in that regard.
Sure. This might be a good time to go ahead and start talking more specifically about Brady violations in general. Just maybe if you give us a little bit of background, John, maybe it'd be good to go to you on this, on what Brady violations are. And we're talked a lot about them throughout this first 15 minutes of the show.
Sure. No, Rod gave a really good background of it, I think. I think the classic example of Brady is when there's material that's directly exculpatory as to the either the guilt or the degree of punishment that would be appropriate for a defendant, when that is either suppressed or even if it's inadvertently it's failed to be disclosed to the defense. I think everybody agrees that under our system of justice and the rights that are afforded under the Due Process Clause, that a defendant is entitled to that information to have a fair trial. And as Mr. Uphoff described before, there are already a lot of the Brady Doctrine has been extended a great deal already. I mean, as he mentioned, it doesn't extend just to the prosecutor or even the prosecutor's staff. It also extends now to law enforcement agencies that may have no contact whatsoever with the prosecutor. It really has nothing to do with misconduct. As he mentioned, it can be inadvertent. It can be there does not have to be bad faith.
And you mentioned, we keep throwing around the word exculpatory and material. Could you explain for the non-lawyers in our audience what those words mean and why they're important?
I was just going to say, and then the third aspect to which it's been extended is, the example I gave you was directly exculpatory evidence. But as this decision shows, it also extends to impeachment evidence, which is not evidence that would directly be exculpatory towards the defendant, but evidence that may discredit one of the state's witnesses or otherwise discredit evidence in the case. And so that's the existing Brady law. So I guess what concerns me about this recent decision is already having an extension of Brady to this degree, to apply it to a relative of a witness who says really nothing more than, I don't recall and I don't want to be a part of this case. As a former prosecutor, I can tell you, we get that comment before every trial, not only from relatives of witnesses, but witnesses themselves. And the information that's being communicated in that statement is not, I don't recall sending a newspaper to somebody. What's really being communicated there is, I don't want to be a part of this trial. I don't want to get sucked into this. Why are people calling me about this case? So I think that's what concerns me, is that, with the level of Brady protection that's already in place, to see the court extend it this much further, I can't conceive of realistically how a prosecutor's office can follow this decision going forward.
I'd like to speak to that because I don't see this as somehow an extension of Brady. I think that this is pretty much a run-of-the-mill Brady case. It's not actually on the more egregious end. I would agree with John that this is impeachment evidence, and impeachment evidence is some of the evidence that tends to commonly not be turned over under circumstances where I think the wiser and better course is to turn it over. But this Brady violation is not as significant as the Brady violation that occurred just down in Texas. There's been a newspaper article media coverage about Ken Anderson, who was a prosecutor down there, and a case that was 25 years old. In that particular case, it wasn't impeachment evidence, but it was evidence, a statement by the child, the 3-year-old child at the time, who apparently told the police immediately after the crime that there was a monster, a man with a mustache who came in, and it wasn't Daddy. And that information was not provided to the defense. The defense didn't know anything about that. And the second statement was a statement by a witness who saw a car and a man close in time to the murder at the house. That information wasn't provided. So ultimately, not only did the Texas Court of Appeals overturn the conviction, but ultimately it led to the disbarment of the then prosecutor who later became a judge. And so I guess my reaction, John, is as somebody who's been involved in the system since 1976, this is not, I don't think this is not an extreme decision. There are always going to be factual disputes, and what I think you and Bill are arguing about is the extent to which Barbara's testimony was it really going to dismantle Jerry Trump, or was it just going to bruise him a little bit? How useful was that information? Because there's a second part of the inquiry. The first is, when you're looking at exculpatory material or Brady material, there are two aspects of it. One is it evidence that tends to show that the defendant was innocent, or as John said, deserves a lesser penalty because it goes to the degree of his involvement? But then the court on review decides materiality. And materiality is really the significance of the information that was not turned over. And this is a classic debate between John saying, I don't think it was that material. It may have been Brady material, but it wasn't that significant because it may have adversely affected his credibility, but it wasn't a game changer. Whereas Bill is saying, and the Court of Appeals said, no, we think it was clearly material. It was so significant that we think it undermines the testimony of Mr. Trump. And that's the problem, I think, with this whole subject of Brady material. To the extent that there's a good prosecutor like John, and in fact, the United States Supreme Court has said numerous times, the careful and prudent prosecutor turns over all that material, turns over all that information, all the Brady material, so that we're not into this post hoc, after the trial debate on its significance. It's turned over in a timely manner, and then the defense uses it, and the jury hears the information and then makes a decision whether or not it's critical or not. But to the extent that it's not turned over, then 9.5 years later, we find ourselves in this pickle arguing about how significant it was or wasn't. That's the root cause.
Well, I discovered something on my around the United States tour just recently, and it was a term that I would like to hear the two esteemed guests talk about if they'd like. It's called the open file system, which they have in Texas. We don't have that here in Missouri. If we had had the open file system, as I understand it, in Missouri, we would have known if Kim Bennett had testified and if her testimony was correct and if it had been put in. Whenever she was asked during the habeas hearing, well, why didn't you come to the court? She said, I told the police. I assumed it had been turned in. If you had the open file system like they have in Texas, she could have gone down to the courthouse and pulled up her own file to see if it was actually there. So if you have a system like you do in Columbia where the interviewee cannot get a copy of it, cannot read it, and doesn't get to sign it, then that is allowing abuse of the system. And I think if we change that, that would probably solve a lot of debates that John and I are having.
But it wouldn't happen in this case because in this particular case there wasn't a report made.
Right, that's a problem in itself.
So your file could have been as open as you'd like, but it wouldn't have helped.
Sure. But there was one with Kim Bennett.
Well, John is unfortunately, John not as unfortunate, but John I think is correct here, Bill, because they have an open file policy in Oklahoma. Bob Macy had an open file policy, but as John points out, if the police don't get the reports into the file, then the open file policy doesn't solve the problem. And Texas is leading the country in exonerations. So its open file policy it's not necessarily a panacea. I agree with you. I think that the more open discovery is, the more information that's turned over by the prosecutor, the less we get ourselves into this situation we now find ourselves. So I agree with you, but at the end of the day, I also agree with John. Just having an open file doesn't guarantee we're going to get the information.
We're going to have to take a quick break, though. We'll come right back to this after the break. A reminder, listeners, this is Intersection, a program of KBIA and the Reynolds Journalism Institute. Today, we're joined by Bill Ferguson, Rodney Uphoff, John Roothouse, and Charles Atwell. I'm Ryan Ferguson. We'll be right back after a short break.